Hi there, my name is Jennifer Diaz, a proud MSI member with Diaz Trade Law, who unfortunately, I'm sad to say, we were not in Malaysia in person. We definitely plan to be, but we are thrilled to have a moment to say hi to you and to talk a little bit about anti-dumping, one of our favorite topics at Diaz Trade Law. I have with me a renowned expert on anti-dumping. So when anyone in the country or really in the world at this stage thinks about anti-dumping, I call David Craven the king of anti-dumping, and we're really proud to have him as an of council member of Diaz Trade Law. Today, we're going to spend a few minutes talking about something we would have talked about more broadly in Malaysia had we had the ability to be with you. So indulge us and let's learn something new, because I guarantee you, most of you in your day-to-day practices don't think about US customs or don't think about anti-dumping. So we're going to start briefly with what is anti-dumping. So David, take it away.
Sure. Anti-dumping is a relatively old concept in trade law. It dates back from the 1920s, but has taken on greater significance over the past few years. And what anti-dumping is an additional duty which is assessed on imported merchandise to offset certain practices. In the case of anti-dumping, it's always a price discrimination statute. And a countervailing duty order is another method of asserting additional money onto imports, and it's to offset foreign subsidies or materials provided at less than the cost of production or tax benefits. And anti-dumping and countervailing duty, in theory, are not penalties. They are simply a financial offset to ensure that the product sold in the US is sold on a similar price. That's the theory. In practice, anti-dumping, countervailing duty end up providing a competitive advantage to the US industry unless they're handled properly by the foreign producer and exporter. And in certain cases, in fact, they can be of benefit, the foreign producers and exporters.
But so to recap, because a lot of you may not have anything to do with anti-dumping or countervailing duties, when I think of anti-dumping, I think of somebody competing with me that's screwing with my margins, that's selling their products at less than what I can actually make them for. At least that's the argument that these US producers are making. It's rooted in protectionism. And then when I think of countervailing duties, I'm the US entity, and my complaint is that whoever's making the goods has a foreign government that's giving them subsidies that can make them sell the goods for lower than what I can sell them for. So I'm complaining about that. Now, the idea that I want everyone to leave home with is US Customs and Border Protection has priorities. And one of their number one priorities is making sure they are the second largest revenue producer in the United States, meaning they want their duties. And when it comes to anti-dumping and countervailing duties, although it's run by the Department of Commerce, US Customs is the one who collects those duties. So when you enter goods into the United States, if your entries, if your merchandise is subject to anti-dumping or countervailing duties, you have to deposit that deposit with US Customs at the time of entry. And Customs has priorities. One of them is money, money, money. That's the number one priority in ensuring they're collecting the right amount of money. So what does Customs do? They audit. And whenever you're audited, I know we've got a lot of great auditors in the room. I want you to think of Jen and think of David at Diaz Trade Law for these audits, because if US Customs is auditing, they're making sure they were paid the right amount to the penny. And these audits are brutal. So Customs, if you look at the amount of audits, they're low, 400 or so audits from 2018 to 2022. But look at the amount of money collected as a result of these 400 audits. Customs is smart. If they're coming after you with an audit, they know there's money there to be found. And then when you look at EPA, which is another topic that I'm ecstatic to talk to all of you about off record, because I need alcohol to talk about EPA, it's the Enforce and Protect Act, where I could yell at David and tell Customs, hey, David is transshipping. He's really making goods in China, but he's shipping them via Malaysia to the US, and he's screwing me, US company, out of my business because he's selling at such a cheap value as a result of him not paying anti-dumping duties, right? And I utilize this EPA process and so on. So what I want you to note from this altogether is Customs takes your country of origin, anti-dumping payments, revenue, all these things very seriously. And if you don't, meaning if your customers don't, anyone who imports into the US have a very good plan on how to deal with anti-dumping, how to deal with classification, valuation, country of origin, all these sexy key topics, you could potentially be an audit risk for US Customs. And these collection rates are really high. There are lots of seizures, lots of trade investigative activities, and lots of audits as a result of underlying anti-dumping issues. So anti-dumping, competing at less than fair market value, whether or not you're getting a subsidy or not, and customs watches carefully over this particular topic. Now, when it comes to what customs is looking at and what commerce does, they're always looking for people that are allegedly making product in a China related country, let's say, and then stamping Malaysia, Vietnam, or other countries on it. So David, talk to us about anti-circumvention
Sure.
and what commerce really believes and what we're doing here.
Anti-circumvention is a relatively new concept, and it is based on the thought that when an order is in place, particularly from a country like China, which has high rates, that the Chinese producers will find a way to move their product in such a way as to avoid the impact of the dumping duties. And that's done a couple of ways. One way, the legitimate way, is for them to build factories in new countries and build up from the ground. A second way is they ship partially made goods to factories in those other countries where they finish the goods, and that may or may not circumvent the order. And the third way is to ship the goods to another country, to take the goods out of the box, to change the label on the box, to put them back in the box and ship them to the United States. And that third is the traditional circumvention. What we're now seeing, though, is a lot more focus by the US on both the first and second methods. On the first method, the US Customs isn't, and the Commerce Department aren't necessarily believing that the Chinese have built factories. They're arguing that maybe these aren't real factories, or they're not producing all of the goods in the factories, and they're checking them and auditing them. And in the case of the second, they're saying you're not doing enough work in Malaysia to make the product so it is no longer a Chinese product. You're merely engaged in a minor finishing operation. And so you could suddenly find yourself subject to Chinese anti-dumping duty orders, for example, shipping goods out of Malaysia that you believe are legitimately made in Malaysia, and they may even be legitimately made in Malaysia.
Now it's your job to prove it for the next
It's
year
your
to
job to
two.
prove it. That's right.
And there's so much risk because look at all these active orders, meaning these are all the active anti-dumping orders that exist and countervailing duties orders that exist by country. So look at Malaysia. We've got 4 orders in Malaysia. In China, you've got many orders, but this isn't just a China issue. You'll see on the list, Mexico, Moldova, Netherlands, Norway, Oman, Pakistan, lots of countries are within commerce's anti-dumping and countervailing duty orders. So this isn't just a China problem. This isn't just any goods made in China deal with anti-dumping, which we hear a lot. A lot of people automatically associate China because China has more orders, more anti-dumping investigations than any other country. But that doesn't mean it's just a China issue.
No, but importantly here, if you only think I only have to worry about dumping by seeing what orders apply to Malaysia, then you're going to fall into a trap. Because while in the old days, that would be a legitimate way of doing this, with these anti-circumvention cases, you suddenly could find yourself trapped in a case that you weren't expecting because it technically doesn't apply to Malaysia. And I think, Jen, and I think you have another slide which really illustrates that.
Absolutely.
There are numerous cases, but 2 of the most prevalent right now are solar panels and quartz. And these are both cases where we have Malaysian producers of product that are falling afoul of the Chinese anti-dumping duty orders because the Commerce Department and Customs Service is questioning whether the operations being undertaken are sufficient to justify the change in origin to Malaysia. And they are now even saying, unless you can certify and prove this, the assumption they're making in both of these industries is that anything shipped from Malaysia to the United States is presumed to be a product of China.
I want you to
Unless-
say that one more time because that's insane, but this is the presumption from customs. If you're shipping from Malaysia, it's assumed that you're subject to China anti-dumping and countervailing duties, regardless of whether you really are or aren't.
And you have to, in the case of quartz, they investigated it. They found no examples of any kind of circumvention occurring in Malaysia, but they said 6 companies didn't respond to our questionnaire. So we're going to assume that those 6 companies were cheating. And so we're going to make everybody shipping from Malaysia go through a complicated certification process. And if you don't do it right, your goods will be subject to the China dumping order.
So
And
here's what I want to
similar thing
make
is happening
clear.
with solar.
It's the solar and quartz are perfect examples, but what do you do if you have a client or a customer in Asia, in Malaysia, in China, anywhere that deals with the United States, meaning they sell product to the United States in any way, shape, or form? I want you to remember that they really, whether they like it or not, they need counsel in the United States that's familiar with anti-dumping and countervailing duties, because there's a lot that they can do in country, even if it's a US proceeding. So David fights, for example, on behalf of manufacturers in Malaysia to prove that they really are making goods in Malaysia, and they can fight separately. The companies who do nothing in this regard are the companies that suffer and get the wrath of the US government by not being a part of the party. So what I want you to take away is there's a lot going on in the United States. There's always a lot. We do newsletters once a month to keep everybody in the loop on what's going on. There are a million ways to keep in touch with us at Diaz Trade Law and David and I on LinkedIn and so on. We want you to keep in touch with us, and we want you to think of us whenever anything US Customs or US Department of Commerce comes along. And when anybody screams about anti-dumping and countervailing duties, we want you to know that you have experts at your disposal that really understand the process. We know what goes on with US Customs, and unfortunately, it's not always a fair process, but you need to have knowledgeable experts on your side to ensure that your client gets the best representation to have the best chance at fighting what really can seem like an unfair process quite often. David, any closing words?
No, I think the only closing word I would have is be aware, pay attention, and take any inquiry that comes in from customs seriously, and make sure you talk to Jan.
Love it. Thanks so much for your time, and enjoy Malaysia. Again, I can't wait to see you when you come to the United States. So make sure to reach out when that happens for the next MSI meeting, and look forward to meeting you all. And sorry again for not being able to be with you. Take care, everyone.
Thank you.